Good morning, everyone. I'd like to welcome you all to today's program to explore options that foreign investors exiting Russia may have to protect the value of their investments. Obviously, this is a timely topic as so many IIB members, other financial services firms, and commercial companies have determined to reduce or withdraw altogether from their investments and operations in Russia. Russia has responded with a series of aggressive countermeasures, and our speakers today will talk about your options in response. We're pleased to have Nikhil, Gore, and David Pinsky, partners at Covington and Burling, to lead today's discussion. Nikhil's practice focuses on advising financial institutions in domestic and international investigations and enforcement actions, focusing on financial crimes and cross-border disputes. David is a partner in Covington's international arbitration and litigation practice, and his recent and quite relevant work includes successfully representing foreign investors in Crimea in response to Russia's unlawful expropriation of their assets in 1994. I think you will agree that we're lucky to have this expertise available to us today. As a reminder, you can submit questions via the chat or Q&A icon on the screen, and we really encourage you to do that. The session is eligible for CLE credit in New York and California. Listen for the code that will be announced at some point in the program in order to verify your attendance on the form that was included in the calendar invite and registration. I think that's it for housekeeping items, and I know there's a lot to cover. So with that, I'll hand the screen over to you, Nikhil. Thank you again.
Okay, thanks, Bridget. I think you've done a great job of introducing Dave and I, so we will jump straight to the substance here. So if you, over the course of today's presentation, we'd like to cover three principal topics. The first is a summary of the countermeasures that Russia has adopted against investors from unfriendly countries, which are essentially those countries that have imposed sanctions against the Russian Federation. Second, Dave will address some of the contractual dispute issues raised by these countermeasures and by the sanctions themselves. And third, I'll talk about how the countermeasures may give rise to claims under bilateral investment treaties. And I'll also provide some specific examples of banks raising bilateral investment treaty claims in what I'll loosely call similar circumstances, even though, you know, the circumstances here are a little unique. Throughout, we do encourage you to ask questions. I think, as Bridget said, we'll be monitoring the chat, so please drop any questions into the chat and we'll respond to them, you know, as and when we see them. And the CLE code will come toward the bottom of the hour. Turning now to Russia's countermeasures. So it's worth starting perhaps with the legal basis of the countermeasures under Russian law. And the legal basis of the countermeasures under Russian law is actually a statute, or for many of them, a statute passed in 2018, which essentially conferred on the president of the Russian Federation very broad discretion to adopt economic countermeasures targeting trade and investment from countries deemed to be unfriendly. The reason I mention this is because if you think about the fact that the countermeasures are arising from a 2018 statute that really is framework legislation rather than a direct legislative response to the current situation, you'll understand that what the Russian government is doing is it's making use of a quite flexible, broad, and in a way hard to pin down set of authorities, and has substantial discretion in how it applies that statutory framework and how it enforces measures after they're announced. And so one of the things that we'll be discussing is that Russia has announced some fairly broad measures, but the way in which it's actually enforcing them is not yet clear. Thinking about some of these specific measures, one area of particular salience for financial institutions is capital controls. And this is an area where the Russian government has been extraordinarily active. Russia's measures fall into two categories. One is really sort of targeted retaliation at investors from unfriendly countries. And another is a broader set of measures that are aimed at essentially stabilizing the ruble. But whatever the motivation behind the measures, the effects on foreign investment are significant. And to get into some of those in a little bit more detail, and you see here on the slide some of the broad categories of capital controls, including fund transfer restraints, restrictions on security sales and distribution, restrictions on performance of foreign debt, and mandatory currency conversions. But to get into that in a little bit more detail, some of the measures we are looking at most closely include, first, a presidential decree, and this is decree number 95 of March 2022, which stipulates that Russian borrowers making loan repayments over a certain amount, 10 million rubles a month, may pay those loans in rubles to special, what are called C-type accounts at the central bank, from which further transfer out of the country is not possible at this time. So effectively, that's a freeze on payments on certain outstanding foreign denominated loans, large value foreign denominated loans in particular. Similarly, there's a broad 6-month freeze in place at the moment from the Russian central bank on large outbound transfers from non-resident companies and individuals in Russia. So even if you do get paid within Russia, you face restrictions getting the money out of Russia on debt instruments, but also more generally on your operations. And as a third sort of broad measure, the Russian government is requiring Russian firms to convert 80% of their foreign exchange receipts, so sales, foreign sales, import revenues, export revenues, into rubles. And that conversion has to happen within 80 days. It's relevant, particularly to the financial services sector, for a couple of reasons, including that it means that Russian debtors are no longer able to maintain substantial foreign exchange reserves, even if that is required under their debt agreements or otherwise. Russia has not just targeted transfers, it's also targeted the securities markets, the debt markets, amongst other things. Just to provide one example, the Russian government has required, or will require in about 2 weeks, that all ADRs of Russian listed firms will have to be canceled. And it's unclear how those ADRs can be redeemed at this point, given the sanctions and the counter sanctions, which leaves potential clients of large banks or international banks like yours essentially stranded with receipts that have to be redeemed, but cannot, as a practical matter, actually be redeemed at the moment. So those are some of the countermeasures focused on the financial sector and financial services specifically. Dave will talk about some of the broader measures that Russia is contemplating.
Thanks, Nikhil. In terms of the broader measures, many of these relate to, as many might expect, to Russia's energy sector, and specifically to its export business for oil and gas and other commodities. But some of the countermeasures that have targeted or that have affected, for example, the gas markets, relate really to Russia's efforts to stabilize or prop up the value of the ruble. And one of them that we wanted to just briefly mention was this so-called Decree 172, which is a new procedure that's been put in place for gas purchases by foreign buyers of Russian gas from again, so-called unfriendly countries. And just briefly, what this does is that originally it was announced that what this measure would do is it would require that Russian gas be paid for in rubles. And the decree has softened somewhat such that the payments may be made in the original currency. So for example, euros, through special accounts at Gazprom Bank that are called K accounts. And then the foreign currency is then converted to rubles before being credited to the Russian supplier. And there are exceptions to this that are allowed based by permit, and it doesn't apply to Russia's LNG exports, only to its the gaseous form of gas exports. Nikhil, do you want to advance the slide? Thanks. Some other countermeasures that we briefly wanted to mention. Two categories are proposed countermeasures. One is that the Russian authorities have been making a fair amount of noise and have proposed legislation that has not yet been adopted that threatens to transfer the control of companies that seek to exit, or transfer the control of assets where foreign companies seek to exit Russia, to Russian administration. So this is just boiled down as really a threat of expropriation of foreign assets to the extent that foreign companies are seeking to exit the country. Another piece of legislation that's been proposed is an administrative and criminal liability for individuals who help companies comply with sanctions. And just by way of background, at our firm, we have a strong group of sanctions-related colleagues who advise companies on trade controls and sanctions issues. And one of the things that has come up is how companies that are seeking to exit Russia and comply with sanctions, how they can ensure that their people who are on the ground are not exposed to criminal liability. And one of the thoughts that's been mentioned is to try to shield, so to speak, the Russian individuals from decisions that are being made on how to comply with the sanctions that are being imposed in light of this potential criminal liability. Other countermeasures that have been put in place include export bans on various products that Russia was exporting, although not on certain energy commodities. And there are also anti-arbitration restrictions that we'll talk more about shortly. So first, the remainder of the presentation is it falls into two parts. The first is we wanted to talk about contract rights, and specifically in the context of commercial or contract-based arbitration and the types of disputes that may arise. And I'll run through these issues, and then Nikhil will pick it up for the next part to talk about so-called investment treaty claims. So first, many of you are likely familiar with commercial arbitration, but just briefly, when we're referring to commercial arbitration, what we refer to are instances or contracts in which parties, typically two businesses, so for banks, so a bank and the borrower, will agree to settle any disputes that might arise between them before an arbitral tribunal under an agreed upon law and procedure, as opposed to in a national court of some kind. And commercial arbitration, it can be used in a variety of contracts. The ones that may be most relevant to this group are contracts relating to project finance, lending to sovereigns, and lending to state-owned or sovereign-owned entities. And what arbitration allows for, by comparison to opting to litigate in national courts, is if there's a greater degree of party autonomy that's allowed. So in addition to choosing the governing law of a particular contract, which you would do whether you're opting for arbitration or otherwise, you can opt for a particular arbitral seat. For example, you could opt to arbitrate in The Hague, which would create Dutch law as the so-called law of the arbitration, or the law of the arbitral seat. You would also be able to formulate the procedures for a given dispute in order many times to achieve a level of efficiency that you may not be able to achieve in a national court. Nikhil, if you could move to the next slide, please. Some of the contract provisions or rights or right limitations that might be triggered or that may be relevant as a result of Russia's invasion of Ukraine and the resulting sanctions regimes include various representations, warranties, and related termination rights, material adverse changes clause, and debt covenants and acceleration clauses. I wanted to just briefly talk about reps, warranties, and related termination rights, and then also just briefly on debt covenants, because they may be the most relevant to what we've seen so far is that those provisions are likely the most relevant in these circumstances. Many contracts that touch Russia in some way, particularly after Russia's annexation of Crimea in 2014, have clauses that relate to the possibility of additional sanctions measures being put in place on Russian parties. And they may, in some instances, provide the contract parties with outs, with the ability to exit if there's a warranty, for example, that can't be complied with. So, for example, if a party that is lending to or that is in a joint venture with a Russian party can no longer perform its obligations under the agreement in light of a more restrictive sanctions measure. And those provisions may trigger the ability of the non-Russian party to exit the contract. And in some cases, what we've seen in advising clients is that they may be able to exit for value as well. The other types of provisions that I just briefly wanted to mention were debt covenants and acceleration clauses. And it's possible, for example, if there's a devaluation of a ruble-denominated asset, that could potentially lead to breach of capital, liquidity, or collateral value covenants, which could then end up triggering disputes. And some of the issues that we've been thinking about include the possibility of whether the borrower can be responsible or may be responsible for the effect of sanctions on issues that result for its business. Let's go to the next slide, Nikhil. In terms of various legal defenses, we wanted to bucket these kind of into three, but I'd separate these three categories into two first. So on the left-hand side is frustration of purpose and impossibility. On the right-hand side is force majeure clauses. Frustration of purpose and impossibility, those are common law doctrines on which parties can rely to the extent they think they have a basis to claim that they cannot, for example, perform obligations under a contract such that it is impossible in the doctrine of impossibility, or that the very purpose of the contract has been destroyed as a result of some sort of intervening event. So frustration of purpose and impossibility, those are the common law doctrines. And what we flagged here is under New York law and English law. And force majeure, on the other hand, is a contract-based doctrine that the application of which is heavily dependent upon the language in a particular force majeure provision. All three of these defenses tend to be very difficult to establish. And just by way of one example, not in the context of the financial services industry, but in the context of the energy sector, where I've had a case, is even in instances that you might think, at least in layman's terms, appear to be ripe for a claim of frustration or force majeure, because of how narrow these doctrines are and because of how force majeure clauses are drafted, may not end up allowing the party that seeks to rely upon them the ability to escape their obligations under an agreement. And the example that I'm thinking of is an instance where a party was selling a commodity to a power plant, or a purchaser of the commodity that ran a power plant, where the power plant was shut down with no possibility in the near term to be reopened. And the power plant therefore no longer needed the source of fuel to run its power plant. But in this particular experience, because of the way that the force majeure clause was written, which was narrowly, and because of the way that frustration of purpose and impossibility are applied, at least under New York law, which is narrowly, the buyer was not able to escape its obligations under the agreement. The current circumstances of Russia's invasion of Ukraine and the resulting sanctions, and also the COVID-19 pandemic, these are types of events, one might say unforeseen events, that lead parties to begin looking at their various contracts rights under force majeure clauses. In addition to looking at whether a party needs to perform its obligations, these types of events are good opportunities for companies to be looking at how they draft these clauses and to think ahead for purposes of new contracts, whether they want to try to broaden those clauses in light of these to date unforeseen events, because it gets people thinking in a creative way. Nikhil, let's move to the next slide. I mentioned earlier that a countermeasure that parties should be thinking about right now is Russia's anti-arbitration law, and this is a countermeasure that actually went into force before Russia's invasion of Ukraine in 2020, where Russia, having not had particular success in international arbitration, was effectively trying to avoid the possibility that Russian state-owned companies and that Russian entities and individuals would have to arbitrate their disputes abroad. And so in 2020, Russia adopted a law that effectively abrogates arbitration agreements. And in 2020, what it did is it granted the Russian courts exclusive jurisdiction over disputes involving Russian individuals or entities subject to sanctions, except where the treaty or agreement between the parties provided otherwise. But even with that exception, the law allowed the Russian individual or entity to avoid the previously agreed foreign forum if the forum created obstacles to justice for the Russian party. And before 2020, a court decision that I'll talk about in 2021, before that court decision, the way this law was applied is that it distinguished between individuals or entities that were subject to asset blocking sanctions versus individuals or entities that were subject to sectoral sanctions, or entities that were subject to sectoral sanctions. And in brief, the way the law was applied said that if there's a risk of your foreign assets being frozen, you might not be able to pay a lawyer abroad. So you can rely on this law to avoid an arbitration agreement. Nikhil, if you go to the next slide, please. And then what happened in 2020, in 2021, is that the Russian courts, the Russian Supreme Court extended that exception effectively to any entity or individual, so the exception being the overriding of an arbitration agreement. The Russian courts found that parties and individuals did not need to abide by their arbitration agreements and could seek anti-arbitration injunctions in a Russian court on the simple basis that if they had been subject to sanctions, period, whether it was asset freezing sanctions or sectoral sanctions. Go to the next slide. So that's one unique barrier involving Russia to arbitration, which is not insurmountable for reasons that Nikhil will talk about later in the context of investment treaty claims. But another potential barrier involving Russia, or the challenge involving Russia in an arbitral context, is that Russia in the past has sometimes, not always, refused to participate in the arbitrations that it had previously agreed by treaty or contract to participate in. And we, in our practice, Nikhil and I both, have seen Russia in the early phases of disputes deciding not to participate, only to later ultimately change its mind and decide to participate when its strategy lent itself towards participating in the dispute. And one thing that's important to note for purposes of arbitration, as distinct from litigation, is that non-participation in an arbitration, whether it's a commercial arbitration or an investor-state arbitration, doesn't lead to a default judgment like it would in a court, for example, in the United States. Instead, the tribunal will want to ensure itself that it has jurisdiction and that the claimant has met its burden on the claims that it's seeking to establish. Another potential issue to be mindful of, particularly in the current context, is evidence preservation. So if a company is seeking to exit Russia, to ensure that it's preserving documents that it may later need in a dispute, or if a company thinks that it might have a dispute with a Russian party, to ensure that it's preserving documents, given that it may be difficult for the company to gain discovery of the documents if they happen to be located in Russia. Also, to the extent that there are Russian employees who might need to provide testimony, it'd be a good idea to begin preserving that testimony now, interviewing the Russian employees to the extent that you would have access to them, in order to ensure that you have access to that testimony in the future. Finally, for purposes of commercial arbitration, I just wanted to flag some issues related to enforcement. So the New York Convention is an international convention that 169 states are party to. And the convention requires that states enforce awards, that their national courts enforce awards that are issued in other signatory states. And what it does is that it means that an entity with a valid award against it can face enforcement anywhere in the world where it has assets. Go to the next slide. And enforcement, one of the benefits of the New York Convention is that when a claimant in an arbitration is going to enforce an award in a national court, it's reducing that award to a judgment. And the application to reduce that award to a judgment is subject to a limited examination. Really what the court is going to be looking at is, was there a valid underlying agreement to arbitrate? And the court will want to ensure that the arbitration was conducted with basic due process. Then the award will be reduced to a judgment. And there are relatively few bases on which the respondent in the arbitration can challenge that reduction to a judgment. And there isn't a basis, for example, to appeal the merits of the arbitral tribunal's decision. So with that, I'll turn it back to Nikhil.
Thanks, Dave. So as Dave mentioned, he has addressed contract-based disputes, and I am now going to sort of switch gears and talk about disputes under Russia's investment treaties. The basic issue that I want to talk about, or the basic problem I want to help address, is what happens when your dispute is not with your Russian counterparty, but rather with the Russian state. So for example, you've received payment from a debtor, but you can't get that payment out of the country, or the Russian government is threatening to take over your assets if you withdraw or close your branches or stop doing business in Russia. Or for example, you have a client affected by Russia's cancellation of ADRs, which is a regulatory measure rather than a commercial measure that a private party can necessarily be held responsible for. And the instrument that can help get at these issues this set of instruments are Russia's bilateral investment treaties. Now, Russia maintains about 60 of these with a range of different countries. But before getting into those treaties specifically, let me explain what investment treaties are. And essentially, the idea is that to facilitate foreign investment, many countries, including Russia, have entered into a network of treaties that provide for a system of investor protections. And these are often called bilateral investment treaties or BITs, although there are also multilateral treaties that fall into this world. And the treaties essentially are meant to allow investors to bring arbitration claims against governments when the government fails to live up to the standards of investment protection that are set out in the treaty. So thinking about Russia's treaties specifically, as I mentioned, Russia has about 60 of these with a very wide range of countries, including many EU states, Canada, Japan, Korea, Switzerland, Singapore, the UK, and actually Ukraine. Now, bid coverage and your ability to bring a claim under an investment treaty depends on generally on being a national of the other contracting state. So for example, to bring a claim under the Russia-Singapore bilateral investment treaty, you would have to be a Singaporean investor. That said, nationality for purposes of these treaties is a little bit more complex than it may seem on the surface. And one important point to keep in mind is that when an investment or when a financial asset is held through a chain of intermediate holding companies, any one of those intermediate holding companies can potentially confer the necessary nationality and therefore confer jurisdiction. And so, for example, there's no US-Russia bilateral investment treaty, but if a US bank or a US company were to hold its Russian investments through, say, Germany or the Netherlands, then the bilateral investment treaties with Germany or the Netherlands may apply. In terms of the substance of the protections that these treaties provide, I started the conversation today by talking about Russia's capital controls, and one set of treaty protections speaks directly to this capital control issue. These are provisions on free transfer, and they appear in, I would say, most of Russia's bilateral investment treaties, and they are actionable for investors. Again, I'm not sure I've counted, but I think it's fair to say in most of Russia's bilateral investment treaties. A free transfer provision is essentially what you think it is. It is a provision that protects an investor's ability to transfer monetary instruments or cash in and out of the invested or in and out of the host state. In other words, it's a free conversion or sort of a free movement of cash clause. Now, this doesn't prevent all capital controls, and depending on the language of the clause, it could allow for some temporary measures. But the Russian Russian treaty free transfer provisions we've seen are actually fairly broad and quite helpful in the present circumstance. And the one other thing I'd point out is that there are fairly, there are sort of well-settled examples of financial services and other investors bringing free transfer claims. So to name just two, there was a case, Border Timbers versus Zimbabwe, involving investors in land in Zimbabwe, where essentially, amongst other things, the Zimbabwean government stopped the land investor from paying its foreign loans and subjected the revenue on the land to forced currency conversion. That was successfully brought as a expropriation case as well as a free transfer case. And was resolved, I would say, I don't know, maybe 2 or 3 years ago now. Another more recent case, I think resolved in the last couple of years, was Air Canada versus Venezuela, where Air Canada was awarded $50 million last year, I believe, basically on the basis that Venezuela was not allowing Air Canada to convert its local ticket receipts and other local revenues into US dollars. So again, established categories of claim that have been useful in politically sensitive situations like the current one. Turning from free transfer to another more commonly used clause, this is expropriation. And if you were familiar with investment treaties prior to this presentation, you're probably familiar with expropriation or nationalization claims. The expropriation clauses in Russia's investment treaties and investment treaties more generally essentially allow claims for the taking or the nationalization of assets. And the important point to keep in mind is that a taking can be direct, but it can also be constructive. It can be a regulatory measure or another measure that substantially deprives an investment of almost the total value of the investment. One point to keep in mind for financial services firms in particular is that an investment doesn't necessarily need to be a bank in Russia or a network of bank branches in Russia. It can be, for example, a financial asset, and that's a point I'll come back to in a few moments. But to begin with, I thought it might be helpful to just put a couple of case examples on the screen in front of you to give you a sense of the types of situations where expropriation cases have been successful. Now, the TechMed case is in a very different sector, and it's sort of an old case. It involves basically a landfill license. The reason I put it up is because it contains a canonical statement of the types of indirect regulatory measures that can result in a finding of nationalization or expropriation. That standard was then applied in the Bank Melli case, which is on the right side of the screen. And this provides an example of a case involving quite, again, a politically sensitive expropriation of a bank, in this case, Future Bank in Bahrain, which was 2/3 owned by two Iranian banks. One reason this case is interesting is because Future Bank had some genuine regulatory sort of AML sanctions related issues over a period of years in Bahrain. Nevertheless, the revocation of its license and the placing of the bank into resolution was found to be an expropriation by an investor state tribunal. And the reason for that was, while the regulatory issues were real, there was evidence in the record that what had caused Bahrain to take action against the bank was actually diplomatic pressure from Saudi Arabia as part of the broader confrontation between the Gulf states and Iran. And again, this resulted in a €250 million award in favor of the two Iranian banks. And it's an interesting example showing that even in a highly regulated sector, an indirect regulatory measure can be viewed and can be treated and compensated as an expropriation. I'll move quickly through another sort of handful of standards that may be relevant to the Russian situation. Russia's bilateral investment treaties contain what are called most favored nation and national treatment protections against discrimination. And so its countermeasures targeting unfriendly countries, which are discriminatory on their face, could very likely fall afoul of these non-discrimination provisions. And turning to another broad concept, fair and equitable treatment, this is essentially a guarantee found in many of Russia's investment treaties that the treatment it accords to foreign investors and their investments will be, as the phrase suggests, fair and equitable. And so what does this mean? This means that the measure cannot be arbitrary, cannot be discriminatory, and cannot frustrate the legitimate expectations of the foreign investor. One particularly interesting aspect of the fair and equitable treatment standard is that many tribunals have held, or several tribunals have held, that it incorporates international conceptions of due process. And what that means, and this comes back to the point that Dave made about anti-arbitration injunctions and the possibility that a Russian court will interfere with your ability to enforce your contractual claims through arbitration. What that means is that if you are subjected to improper process before a Russian court, if a Russian court is interfering either with your local assets or with your right to enforce those assets through contract, that may give rise to a claim under the Fair and Equitable Treatment Clause or the due process prong of the Fair and Equitable Treatment Clause. And it may also, if the interference is sufficiently broad and long-lasting and essentially sort of deprives you of the entire value of the claim, may also actually give rise to an expropriation claim. Again, just a couple of quick examples of how financial services firms have used the fair and equitable treatment standard. So the Saluka case involves a subsidiary of Nomura, which owned a stake in a bank in the Czech Republic. And there the case was essentially brought, or it succeeded anyway, on the grounds that the Czech Republic provided state aid following a bad debt crisis to domestic banks, which it did not provide to Saluka, or rather Saluka's local banking subsidiary, IPB, which resulted in IPB ultimately being placed in insolvency. And so the failure to provide state aid was discriminatory and arbitrary and contrary to the fair and equitable treatment standard. The Lyon versus Mexico case is sort of one of these due process examples I provided, or I mentioned, where essentially Mexican courts were failing to enforce and deal appropriately with commercial mortgage lending agreements. And essentially when the local court failed to enforce those mortgages against a dishonest and politically connected local businessman, the investor was able to bring an international claim and obtain damages for the value of those mortgages. Moving on, we've covered in some depth a number of these specific protections in bilateral investment treaties, but the point I want to make on this slide is that there are actually quite a number of substantive protections in many of Russia's investment treaties. I won't go through these all point by point here, but one point I will note is that Russia has entered into treaties that contain war compensation clauses that, amongst other things, might be read to permit a claim again when Russia provides war or emergency related assistance to domestic banks and financial institutions that it does not provide to international banks, including international banks with assets trapped in Russia. This is, again, another slide that provides a series of examples of financial services investors using bilateral investment treaties in practice. This is across a range of different theories. And the point to flag here is that the types of investments that you might be that might be amenable to a claim are, as I mentioned, broader than you might think. So it's not just actual banking operations in Russia. So starting with the case on the far left involving Deutsche Bank in Sri Lanka, the investment there was a hedging agreement, an oil-related hedging agreement. Skipping to the far right, the investments in a series of cases against Argentina, some of which were successful, some of which were not, but the investments in a series of those cases was basically state debt, sovereign debt. And similar sovereign debt cases were brought against Greece and Venezuela during their defaults. Again, the results have been mixed, but some of these cases have been successful and have allowed for meaningful recoveries. So I think the question that is at the back of a lot of our clients' minds is, well, you've told us about the claims we can bring. You've told us about claims we can bring against the Russian government. How do you actually get money out of the Russian government? And frankly, that's a good question, and it's a tough question. Before I answer it, because we are 45 minutes in, let me briefly provide the CLE code, which is 3HWY. And to say it again, that's 3HWY. And I think the instructions are on the form, but once you filled in the code and filled in the form, you can return that to Haley Kennedy, which is hkennedy@cov.com, and her email address again is on the form. Okay, so getting back to how do you actually obtain money from the Russian government if you are able to get an award under an investment treaty? Well, generally speaking, the procedural answer is similar to what Dave described with respect to contract arbitration. So you can use the New York Convention. There are also sometimes specialized treaties that may apply. And in many cases, in many countries rather, including in the US, there are limited waivers to sovereign immunity when you are enforcing an arbitral award, including a treaty-based arbitral award against a state. That said, the exception to state immunity doesn't apply to all assets. So for example, in the US, you can enforce an arbitral award against a foreign state against its commercial assets, but not, for example, its diplomatic assets. So you can't go and attach the Russian embassy in Washington, DC, for example. Countries also will often respect the distinction between a foreign state and its state-owned enterprises. And so in the case of Russia, it's not necessarily the case that you can automatically go ahead and say, attach the assets of Gazprom or of Rosneft, even though those are, of course, commercial assets when you are dealing with an award against the Russian state. That said, with respect to Russia specifically, governments are looking closely at waiving and or modifying the standard immunity doctrines that may apply. And much of this discussion at the moment is focused on allowing human rights claims rather than commercial or investment claims. But some of the legislation that's being proposed is sufficiently broad that it might cover both. In addition, we think that to the extent investors, including banks, bring successful investment claims, there's a reasonable possibility that some of the key home country governments will look at ways to force Russia to pay those judgments, for example, as a condition for normalizing economic relations with Russia at some point in the future. Russia's increasingly politicized use of its state-owned enterprises and frankly of, and of some enterprises that are not state-owned, also raises substantial questions about the extent to which the legal separateness of those enterprises should be or will be respected. So as I mentioned, in general, a state-owned enterprise is viewed separately from the state itself. But at the same time, as in any case, you could try to bring veil-piercing alter ego type arguments. And there are some who would say that Russia is engaging in conduct that sort of raises those issues to the fore. More immediately, firms with significant claims or awards can consider working with asset tracing and collection firms that may be willing to purchase awards at a discount and then sort of take action to enforce them. And you see this, I mentioned the Argentina debt default cases. So you see this with funds like, for example, NML Capital coming in, purchasing the debts or purchasing the claims, and then sort of taking aggressive action to enforce them. Now, the truth is none of these strategies is fast or easy. But what this means is that while it may not be economic to bring a claim for a small loss, where there are significant damages, it's worth thinking about whether the cost and effort could be worthwhile. All right, well, that is the end of our, I would say, pre-planned presentation. What we'd really like at this point is to hear any questions the audience may have. We're happy to take those live here through the chat. We're also happy for folks to reach out to us, and our email addresses and phone numbers are on the screen. But why don't we leave the line open for a minute or two to see if there are any questions.
And reminder, you can submit questions either through the Q&A or the chat, or if you're on the phone, you can email at info@iib.org. A question did come in via email that I'll ask. And that question was, based on your experience to date, and you went over some of this, but are there particular things that companies should put in place now, or are there things that the other way, I guess, to ask it is, are there actions or provisions and agreements that turned out to really be a roadblock to pursuing the various remedies that you have outlined? Like, what can people be doing if they're thinking ahead, this might happen and I might want to avail myself of these options?
Dave, you want to start?
Yeah, I could start. I think there's probably two categories, one relating to the commercial side that I was discussing, and one relating to the investor state side that Nikhil was discussing. On the commercial side, what we're seeing based on our conversations with companies and clients that are facing these issues is that the companies that are in the best position across sectors are the companies that plan for the possibility in their commercial agreements that Russian sanctions would get tighter over time. I think it's fair to say, I certainly would say this from my own perspective, doing a lot of work for Ukrainian clients and in disputes adverse to Russia, that at least before November of this year, the possibility of what's happening now was really not within the realm of possibility. But it was possible that sanctions would tighten a little bit. And so based on just Russia's historical conduct in Eastern Europe and with respect to Ukraine in particular. And so that's something I think that companies, banks should be thinking about, is looking at their rep and warranty and trade restrictions provisions, and potentially looking ahead and writing it, looking at whether they have these provisions now that to the extent there are obligations that they want to get out of, or potentially if they want to be on the other side and not allow a party to have the flexibility to get out of their obligations based on more strict trade restrictions. The same goes for force majeure provisions. Remember that the doctrines of frustration of purpose and impossibility, those are common law doctrines, but force majeure provisions, you write those into your contracts yourself. And so the other thing to be thinking about is, are my force majeure clauses, like many companies have template force majeure clauses, are those force majeure clauses broad enough if we want to rely on them, or are they too broad if we think the other side might be relying on them? But to really to take these facts and analyze those provisions in light of that. On the investment treaty side, and Nikhil can speak a little bit more to this, the other thing that we're seeing is that companies now are thinking about how do they hold their investments in Russia, or if they have contracts with a Russian party, because of the potential application of umbrella clauses in investment treaty agreements, which really turn contract breach, simply put, they turn contract breaches into possible investment treaty claims. Is the party that has the contract with the Russian entity or with the Russian state potentially, is that in a jurisdiction that has a favorable bilateral investment treaty with Russia? Or is the investment that's held in Russia, is that held through a party, through a country that has a favorable bilateral investment treaty in Russia? And if it isn't, should we be thinking about restructuring these agreements or restructuring the holdings? Nikhil, anything you want to add to that?
Yeah, just two quick things. I mean, I think, one constraint that banks face in kind of putting in sanctions related clauses is that that's going to be driven fundamentally by compliance considerations and enforcement considerations. And so creating flexibility where you might still somehow get paid, drafting a sanctions clause that allows you to continue to get paid by some unsanctioned entity, while also, your sort of compliance folks are telling you what you need to do is just cut it off because no amount of payment is worth the risk of OFAC coming against you. It is tough. And so one of the things we've been doing, frankly, as Dave alluded to earlier, is sort of you've got to kind of sit down with a civil litigator, a sanction specialist, and frankly, even within a law firm or within a legal department, hash that out a little bit and sort of see where the balance lies. And it's going to be different for different firms. The other point I'd make is, if you're sort of exiting Russia, or you're trying to sort of reach settlements with Russian counterparties in light of the present situation, you need to think about the seat of arbitration. This is the point Dave made with respect to the anti-arbitration law. Because if you sort of default to, okay, it's a Russian party, we're going to arbitrate in Stockholm, or, arbitrate everything in London, we're going to arbitrate in London, you will end up potentially with procedural issues in Russia that, you may have faced anyway, but might be a little easier if you were to think of some other seat. And one of the tough things that we're working through now, because Singapore, which you might have thought of as sort of a backup seat, is also on the unfriendly countries list, is where can you go where you're going to have some decent arbitration law and your arbitration award is going to be confirmed by the local court, but at the same time, you don't run afoul of these Russian counter sanctions. And there are options, but again, they're fairly case specific, and they're issues we're working through with clients at the moment.
Do you see your clients looking beyond Russia, like thinking ahead to other geopolitical tensions and starting to think, in other words, making this, sort of a standard practice versus the reactive to this particular situation?
I think that
or are your remedies so Russia specific? Which I would understand if that's the answer.
So they are not Russia specific. So I think all the doctrines we've been, Dave was talking about general commercial law doctrines under, New York and English law. I was talking about doctrines that appear in a range of investment treaties. I think the sensitivity is that if you think about the other country that might end up in a similar situation, but if you're thinking about other places where there may be sort of military action of this sort, it's tougher to account for. It's a challenging question, sort of a good question, but you sort of you would be running into such significant destabilization, economically generally, that you can sort of prepare in your contracts, but but I do think it is a good opportunity, as Dave said, to sort of think more broadly about, do all your contracts anticipate compliance outs? Do they all anticipate sort of sanctions, but not just sanctions, trade controls, reputational, the ability to exit for reputational reasons or because other clients are demanding that you do so. And then, there is a little bit, I don't want to say the playbook, but there are cases that have arisen out of, say, the Iraq War, as well as actually the Iraqi invasion of Kuwait. There are cases that have arisen out of Saudi Arabia's actions in Yemen and Iran's actions in Yemen. And so there are sort of, other sources you can go to that inform how you respond to this situation and to future crises.
Great. I think that's it on questions. Dave, Nikhil, thank you. This was really helpful. Their contact information, both Dave and Nikhil's, is on the screen, also available from the IIB, or you can Google them. We appreciate your time today and your willingness to have people follow up with you. Thank you for thinking of the IIB and being such good friends to the IIB. We appreciate it, and have a great week.
Thank you. Thanks, everyone.
Thank you.